Hi, I'm here with Kathryn Sanger from Herbert Smith Freehills. You were one of the excellent panelists today and discussing what was arbitral. In your opinion, are insolvency proceedings arbitral?
Well, I think it's accepted. There is obviously a natural tension between the insolvency process and the arbitral process. So insolvency, what we term the core insolvency process, is by its very nature public, it's centralised, it's regulated, and it's for the benefit of all creditors, not just those who've signed an arbitration agreement with the company. Arbitration, of course, is the opposite. It's confidential, it's decentralised, it hinges on party autonomy. So it's the ability of a company to contract directly with creditors. So the core insolvency process, I would say, generally not arbitrable. And the courts have been quite clear that winding up petitions don't trigger the stay provisions that would normally kick a proceeding out of the court in favour of the parties' agreement to arbitrate. But and consistent with that, the Singapore courts recently have said that claims which arise because of the insolvency regime also not arbitrable, so avoidance claims. And that's because, of course, these are claims of the liquidator, not derivative of the debtor's rights. But there is case law in England and in Singapore which shows that the courts are willing to at least entertain and uphold, entertain private claims that arise from a company's pre-insolvency rights and obligations, where the rights of other third-party creditors who don't have arbitration agreements are not affected. So we're seeing a move in the right direction, certainly.
And there's a couple other topics other than insolvency that discuss IP, intellectual property disputes, as well as, I believe, shareholder rights. Yeah. And it seems as if are there any other sort of areas where it's sort of disputable as to whether or not they're truly arbitrable?
I think sort of classic examples, sort of matrimonial disputes, so just any disputes that deal with, for example, rights of children. In England, there's been a push recently for financial disputes relating to breakdowns of marriages because there are special schemes set up and they can be arbitrated, but where rights of children are involved, then the courts still play a role. Recently, I had a case where we were arguing about the arbitrability of fraud as a matter of Indian law in an international context, but now we've had decisions coming out of India that now make it clear that in at least an international related offshore arbitration, then fraud and fraudulent misrepresentation claims are arbitrable. But that was until, I would say, 3 or 4 years ago, also a question mark as a matter of Indian law. But family-related disputes, some employment disputes, have historically been found not to be arbitrable. But we're seeing there's definitely a global trend where non-arbitrability everyone is saying is shrinking.
Great, thank you so much. Appreciate it.